Hello, this is Heidi Palutke, Senior Vice President of Compliance and Education for the California Apartment Association. In this presentation, I will cover the legal responsibilities of landlords and tenants when it comes to bed bugs at residential rental property. When we talk about legal compliance related to bed bugs, this is something which affects the tenancy at all stages, from showing the rental unit to maintaining the unit to eviction protections for tenants who report bed bug infestations. There are several laws that address issues related to bed bugs in California. Some of these are generally applicable laws about the habitability of the unit, while others are specifically focused on duties related to bed bugs or on pest control by the landlord. On the screen are the three laws I'm going to focus on in this presentation. You all are likely familiar with the warranty of habitability in the Civil Code and the substandard housing provisions in the Health and Safety Code. The law on habitability basically addresses the obligations the landlord has to the tenant. This spells out the condition of the unit that must be met throughout the tenancy in order for the tenant to be required to pay rent. On the other hand, the substandard housing provisions set out the minimum conditions that a rental unit has to satisfy in order to be operated legally. And these provisions are enforced by your local code enforcement officials. The two laws cross-reference each other, though, so both sets of requirements apply in each context. The third bullet that you see on the screen here, AB 551. This is a law that was passed in 2016 and took effect in 2017. This contains specific requirements, including a lease disclosure requirements on landlords relating to bed bugs. So let's start with the Civil Code. This law says that a dwelling shall be deemed untenantable for the purposes of 1941 if it substantially lacks any of the following affirmative standard characteristics. And you can see at the bottom of the slide that this includes being free from an accumulation of vermin, and that would include bed bugs. So the takeaway from this slide is that the landlord is responsible for providing a unit that is pest-free at move-in and has an ongoing responsibility for conditions that are in areas under the landlord's control. This ongoing responsibility is going to include keeping bed bugs from wandering from one unit across the hall to another unit. And the courts have consistently held that landlords have a responsibility to keep the premises habitable for the duration of the tenancy. So the other housing law that addresses infestations is the Health and Safety Code provision regarding substandard housing. This provision requires an infestation of insects to be confirmed by a health officer or code enforcement officer. If an infestation is found, the landlord can be cited if it is not promptly corrected. This law isn't limited to the condition of the unit at move-in, and it's not limited to common areas under the landlord's control. A question that comes up all the time on our landlord helpline at CAA is, who is responsible for the cost of bed bug treatments? California law puts the primary responsibility on the landlord to correct habitability and substandard housing issues and to bear the cost of doing so. While California law does impose some duties on the tenant to maintain the premises, it's unlikely that a court will relieve the landlord of responsibility for remedying a habitability issue, unless it's very clear that the tenant caused the issue, for example, by failing to remove piles of garbage or other waste from the unit. Some rental agreements include a provision which says the landlord can pass on the cost of correcting issues to the tenant where the tenant caused the problem. However, it's unclear how this would play out in court with respect to bed bugs. So what is a landlord to do in this situation? Our recommendation is that if you do have a bed bug issue, focus first on getting the issue treated as promptly and effectively as you can. As you'll hear in the other presentations, early detection and treatment of bed bugs are the keys to success in controlling bed bugs. Then once you've had the treatments done, you can consider whether it's appropriate to pass along the cost. The decision of whether you can pass along the cost of a bedbug treatment must be made on a case by case basis. There's really no bright line rule. One thing to consider is that it's often nearly impossible to pinpoint the source of the infestation. You should also consider that you want tenants to report suspected infestation so that you can treat any infestation early. And if you tell tenants they're going to have to pay for the treatment, they may be less likely to report that infestation before it gets really, really bad. One decision that's easy to make is the decision to treat the infestation as soon as possible. If there is a problem in one unit, even if it's somehow clearly 100% the fault of the tenant in that unit, it still needs to be promptly addressed by the landlord, because when the bed bugs spread to the other units, that is definitely the landlord's problem. And you also don't want the tenants in any of these units taking matters into their own hands and trying to treat for bed bugs themselves. So, what happens if the landlord does not fulfill the duty to provide and maintain habitable premises? There are a number of remedies that are directly available to tenants if a tenant reports an infestation and the landlord then fails to take action. First on the list here is reporting the issue to code enforcement. In this case, a code enforcement officer or health officer will come out and inspect, and if they find an issue, they will require the landlord to fix it, and they may also assess a fee, and if it's not corrected, a penalty. Tenants also have the right to repair and deduct for habitability issues so long as the cost doesn't exceed 1 month's rent. This is not really something you see with bed bugs, because treatment of bed bugs typically involves treating several units, and the cost is likely to exceed one tenant's monthly rent. Tenants can also withhold rent, and then raise that rent withholding as a defense to not a non-payment of rent eviction. Um, Tenants can also move out and stop paying the rent and then sue the landlord for breaching the warranty of habitability, because, like I mentioned earlier, the tenant's duty to pay rent is linked to habitability. So if the unit is not habitable, then the tenant does not have a duty to pay rent. Or if it's only partially habitable, there's only a partial duty to pay rent. So the next law on our list, AB 551, specifically addresses bed bugs at residential rental property. This law took effect January 1st, 2017, and contains several requirements for landlords related to bed bugs. The most important requirement is that mandatory information about bed bugs must be provided to all new and existing tenants, and that information must be included in all new and renewal rental agreements. The law also prohibits the showing and renting of infested units, and it requires that landlords notify tenants of inspection reports within 2 business days of when the inspection report is given to the landlord. In addition, the law prohibits retaliation against tenants who report a suspected bedbug infestation. The purpose of this provision is to encourage tenants to report suspected infestations, because the earlier an infestation is identified, the more quickly and effectively it can be treated. So the first piece of this law is the mandatory bedbug information for all tenants. This information must be included in all new and renewal rental agreements entered into on or after July 1st, 2017. There was also a requirement to provide the information to existing tenants no later than January 1st of 2018. That's, of course, in the past now. So there are 2 pieces of information that have to be provided to all tenants. The first is basic information about bed bug biology and identification. The second piece of information is the contact information for the specific person at your property that the tenant should contact if they suspect an infestation. So CIA has several forms which can be used to comply with the requirements of this law. CIA's updated rental lease agreements all have the mandatory language included. Um, if you need a separate form, Form 63 is the bedbug notification addendum. This can be used with any new or renewal, rental, or lease agreement. A 30-day notice of change in terms of tenancy could also be used to incorporate it for an existing tenant. In addition to containing all of the statutorily required language, this addendum includes additional provisions which require the tenant to cooperate with preparation of the unit for treatment. Of course, if a tenant is disabled or for some other reason cannot do the unit preparation, that is something that you would need to work with your tenants and potentially a fair housing attorney to resolve. This is a situation where a reasonable accommodation could be appropriate. For example, a disabled tenant may need something as simple as additional time to get ready for a bed bug treatment. One more thing to note on this form that I don't expect you to be able to read on the slide is the blank lines in the bottom half of the page. This is the section where you need to fill out the contact information of the person you want the resident to contact if they suspect an infestation. This could be the property owner, a property management company, or on-site property manager, or it could be, in some rare instances, maybe the pest control operator with whom the landlord already has an ongoing relationship. The law does require this information to be filled out. Later in this presentation, I'll talk about some of the other provisions we've included in this form related to bed bugs that are not required by law. So under this law passed in 2016, it's illegal to show a vacant unit, which is known to be infested with bed bugs, to a prospective tenant. So if you know there was an infestation in a vacant unit, you need to treat that unit for the bed bugs before you can even show it to prospective renters. And of course, before you actually rent out the unit. So one good thing about this law is that it's not just a long list of things the landlord has to do. It also gives the landlord the authority that they need to carry out their obligations under the law. So there's now a right of entry for the pest control operator who is inspecting for or treating a bed bug infestation. This right of entry allows the pest control operator to inspect any units they select. It's not just the one unit of the person who reported the suspected infestation. If the pest control operator wants to inspect a number of surrounding units to ensure the most effective treatment, they can do that. Similarly, the law allows the pest control operator to perform follow-up inspections. Like with other types of entry into the rental unit, the tenant does have to be provided with at least 24 hours written notice as required by Civil Code 1954. If you need a refresher on how to provide that notice of entry, CIA does have a paper on the topic of entering the unit, which you can find on our website. Then, once you have the results of an inspection by the pest control operator, you have to provide written notice to the tenants whose units were inspected within 2 business days, and that notice has to tell them what was or was not found in their units. If the inspection was of a common area, then all tenants have to be provided with that notice of the inspection results. Another key provision of this law is the protection from retaliation for tenants who report a suspected bed bug infestation. Protection from retaliation is not a new law. It's long been illegal in California to retaliate against a tenant who exercised rights under the law, such as reporting a habitability issue to the landlord or to code enforcement. The new law simply extends this protection to specifically apply to tenants' report of a suspected bedbug infestation, and it creates a presumption that a landlord who seeks to evict the tenant, to raise the rent, or to decrease services provided to that tenant within a 180-day period after the tenant reported the suspected infestation, the presumption is that that landlord is acting in retaliation. Of course, if you have some other valid ground for the eviction or for the rent increase, which you can prove, then you can certainly overcome that presumption of retaliation in court. So I mentioned that we have some additional provisions in our CAA forms that address bed bugs. You'll see those on the next 2 slides. The purpose of these provisions in the form is to let the resident know the importance of prompt reporting, not only of suspected infestations, but also of other maintenance issues that could make a future infestation more difficult to treat. And then on the second slide, these extra provisions tell the resident what to expect if an inspection or treatment is needed, including the possible need for unit preparation and for the resident to temporarily vacate the unit. The Bedbug Addendum and CAA's rental agreements also contain some prevention tips for the resident. These are not mandatory enforceable duties. Rather, this is an educational piece that tells the tenant what precautions they can take to avoid bringing home unwanted guests, being bedbugs. So this next slide, it might hurt your eyes. Feel free to look away. This addresses a recently enacted California law that requires landlords who apply pesticides themselves, rather than hiring a professional, to provide a specific notice to their tenants. Different notices are required depending on where the pesticides will be applied. In some cases, notices must be provided to a single unit or to neighboring units, to all units, or posted in common areas. CAA has about half a dozen forms that can be used to comply with this requirement. The purpose of the flow chart is to help you figure out which form has to be used in each particular situation. As a practical matter, the purpose of this flow chart is to underscore CAA's strong recommendation to not do it yourself. Do not apply pesticides yourself. Call a pest management professional. The result will be safer for you, it will be safer for your tenants, and the treatment will be much more effective. And you don't have to damage your eyes by looking at the flow chart. So that is the end of my presentation. Thank you for joining me today. All of the forms and papers I mentioned are available on the CAA website at www.caanet.org. Thank you for listening.